government, which is what will be cognizable and non-bailable, then that will be governed by 91(2). There it will be produced to the magistrate. Otherwise, it will be governed by 91(3). The officer is bound to release you on bail. Then what is the meaning of cognizable and bailable? You kindly come to (90) subsection 2, 90 subsection 91 and 90
subclause 1?
Subsection 1.
An offence under clause Roman 2 of subsection 1 of section 89 shall be
cognizable. This is where we collect and don't remit. That will be 89(1)(2). That will be cognizable. Okay. Then
subclause 2 of 90. Notwithstanding anything contained in the CPC, all offences except the offences specified in subsection 1 shall be non-cognizable and bailable.
So, 90 subsection 2 makes it clear that every offence in the Service Tax Act except 89(1)(2) is non-cognizable and bailable. Non-cognizable in the sense criminal prosecution cannot be initiated without leave of the court. That's one part we are not really concerned with that. And bailable. So anything other than 89D, related to 89(1)(2), that is collected and not paid for more than 6 months, where the amount exceeds 50 lakhs, then every other offence will be bailable and is bound to release on bail. Clear now, sir, so far?
Yes.
No complications? Okay. Again? Okay.
Sir, is there any provision of anticipatory bail in this?
When anticipated bail will not be governed by this act, it will be governed by CRPC. And in Maharashtra, anticipated bail provision is there. But there is no need for an anticipated bail because the offence is bailable. Automatically, the authorities will release on bail.
It's a non-bailable.
For non-bailable, you can, non-bailable certainly can go for anticipated bail. There is no problem on that. Theoretically, yes. But there you have to be careful. If the non-bailable in anticipated bail is rejected, then you are in difficulty. So you must carefully wait. We will come to that in a minute. We will come to that in a minute. So therefore, except cases of collection not paid for beyond 6 months for about exceeding 50 lakhs, then there is otherwise no arrest. Or the arrest is technical in nature. Okay. So that's one part. Now let us come back to 89(1)(d). Can we read 89(1)(d) only?
I'll start D first.
D only.
Sorry. The upper line is whoever commits any of the following offence, namely knowingly evade the
D only.
Okay. Collects any amount as service tax, but fails to pay the amount so collected to the credit of central government beyond the period of 6 months from the date on which such payment becomes due, and then it shall be punishable.
Now, okay. So 89(1)(d) offence separately will be tried for prosecution excess that may take ages, but that can be ground for arrest and you will be brought to a magistrate. Bail has to be done to the magistrate. Officer cannot be done. It's a discretion of you. Okay. Now, 2-3 points which we want to discuss. I am not saying I am right in it. Collects any amount of service tax. Here refers to actual collection. Invoicing will not be collection. Under the Act, post 2011, your liability to pay service tax is on accrual basis. Is on accrual basis, whether you see payment or not. But for purpose of 89(1)(d), when section refers to collects amount of service tax, it is not referring to invoicing. There is a problem in the later part of the section beyond 6 months when it is due. That we will come to that later. What I want to emphasize is collects any service tax and does not pay to the credit of the government. You invoice the customer does not pay. Your liability to pay service tax at the Rule 6 and point of taxation rules etc. might have occurred, but that will not be ground for arrest or prosecution. Collects here means physical act of collection. Why? You are dealing with the taxing statute. You are dealing with the criminal provision in taxing statute and has to be strictly construed. So, if you invoice the customer, this is not a section for delaying payment of tax. If you delay the payment of tax, only provision is interest. Even the ABC do not apply. You don't pay the tax to the due date, that's a different matter. You are 75, 76, 78, etc. will take care. So collect here means actual collection, not invoicing. Because what Rajesh was saying is, in number of cases, the customers do not pay for 3 months, 6 months, etc. Okay, in security agencies. That's one point. But the counterpoint to what I said is, but fails to pay the amount collected to the credit of the central government beyond a period of 6 months from the date on which such payment becomes due. So here, later part says such payment becomes due. It becomes due the day you invoice. It becomes due day you invoice. They will wait for 6 months the day you invoice. But first part refers to collection. The answer to that is, even though the second part refers to 6 months the day it is due, first part still refers to collection. The second part is only indicating how long they will wait before prosecuting. It is how to calculate the time till which his patients will wait and beyond which his patients will wear out. So, the later part of the section, within 6 months the date payment become due. Payment may become due on the date of invoicing. But suppose a customer has not paid you for 8 months. He has not paid for 8 months. First part of the section is not attracted. There is no collection and therefore it is not applied. That's the first point I wanted to emphasize. So, sir, you want to say something? No, I was trying to say. Thank you. Because I don't want 100 of them to carry it.
Sir, one question.
Yes, sir.
Sir, in case of the service, tax are not separately charged in the bill.
Yeah, correct. Just 1 minute. I'm older and therefore slower. The good point. I'm grateful to you for asking it. If I miss it out, kindly, okay. Second, this section was introduced from what date, sir?
10/5/13.
2013. Okay, whatever date it is. So, in criminal law offences can never be retrospective. So, in cases you have collected earlier prior to the date and not paid, even for 10 years the section will not apply. Because this is transition provision. This will not be used for 2 years later. After service tax is abolished, as requested by our president, this question may not arise.
But sir, they have applied. They have applied. In Ahmedabad, they have made 2 years.
And the magistrate also said section is not retrospective, released him also.
No, they have given just bail.
He said on the reason that section is not retrospective, it's not a continuing offence, therefore.
So thereafter, second arrest also came on the same ground.
For the offence to take place after that date, for collections made after this date, this section will apply. I am only saying it's a transition provision, okay, and this will not be exhaustive of all the situations, but just want to, as I said, this point will not be relevant 2 years later. Is that yes, sir?
What will be the date of offense? Whether the completion of 6 months?
No, date on which you collect. Date on which you collect. That's why I said don't delay by 10 years also. The offence is committed the day you collect and don't remit. Okay. I'll come to that in a minute. So, that 6 months is not yet over by the time amendment came, etc. not relevant for this. The offence, this section is not retrospective because no criminal provision is retrospective. Secondly, the gravamen of the offence is collection without remitting. So that the offence takes place on that day. The prosecution argued there's a continuing offence and therefore, in view of the judgment of Supreme Court Meyer and Ipunj, it will. They say continuing offence should be offence, it's an offence every day. For example, failing to file a return. Every day the delay continues, it's an offence, continuing offence. It's not an offence taken place on one particular day. But at least in a case, the court magistrate court in Ahmedabad held also, there is not a continuing offence, that's debatable. But in a case of this type, the liability to pay occurs at one particular time, namely forthwith you must pay. So therefore, it may not be a continuing offence. Even if it's a continuing offence, I am not sure. If on the first day it occurred, the section is not applicable. On the day subsequently it continues, it can be applicable. It's a debatable point. More than one use possible on that. That's the second. 3, that may not happen in practice, but just for completion in the discussion. if you collect it provisionally or tentatively with a liability or an intention to return to the customer, you don't know about the taxability. You don't know about the taxability, but you then collect it. Okay. But you tell that I will return it. Or in your book show it the liability account, liability to the customer. Okay. That is provisional collection with an obligation to return it back. Our Supreme Court in R.S. Joshi's case held 39 days years. R.S. Joshi, Ajit Sugar Mills. Ajit Sugar Mills. Collected is collected and retained as yours. Collected with a liability to return will not be collected. So, many cases, the Supreme Court said, the parties argued, your section says anybody who collects it should have to pay it to the government. Otherwise, they put penalty. Then the assessee argued the section is unconstitutional because many cases pending a dispute, I will collect it, I will agree to return to him. Your section says no one you collect, I will forfeit it and I will put penalty on you. Then Supreme Court Justice Krishna has said, we contextualize the section and follow an Australian decision saying collected here means collected and retained as yours. Collected the liability to return, a provisional collection will not be collected. That's what Supreme Court has said. There's another judgment of Supreme Court Mysore spinning mills also, sales tax, both are sales tax, both are constitutional benefits. Saying collected is an obligation to return or a liability to return or intended to return will not be collected. Okay. Last part is what my friend asked. Collects any amount as service tax. Okay. So this section says collects any amount as service tax but fails to pay. If you collect as part of price, he says I don't show service tax separate in the invoice. I don't know. That may be compliance with rule 4, whatever is 4A. 4A. That requires you to show separately. Also your earlier Central Excise Act will separately require to show what is the this thing. But in a case where your invoice doesn't show the breakup, it may be breach of 4A, but that will not amount to collection as service tax. You see, there is a breach of rule 4A. Okay, that will be a different matter. But that will not attack 18 and 1D. Collects any amount of service tax means you must tell the customer I am collecting a service tax. You collect as part of price, that will not be covered by this. Okay. Collects any amount as service tax. Moolchand Shamla. Moolchand Shamla. I don't know the citation. UP sugarcane says some purchase tax is levied or flour mill, and collected as tax means as representing tax. So you make a lump sum price that will not be collected as service tax. So Moolchand Shamla. Moolchand sounds आपको मालूम है सर.
Sir, in spite it is mentioned on the bill, it is inclusive of service tax.
Make sure it is. Inclusive, okay. You don't show the breakup, but inclusive service tax, also no problem. 50 STC, Gujarat High Court. It only means you assure the buyer that you will not make a supplementary claim on him later. Inclusive service tax does not mean any particular amount is included in it. For the purpose of refund and unjust enrichment, that may be different. Because there, incidence of duty is passed on, you will not get refund. Incidence of duty is passed on, you will not get refund. That language is different. Collect any amount as service tax. So there is a representation claim as service tax. So lump sum amount collected, no.
Sir, one more variation here. I have raised the bill for 50 lakhs rupees, 12% service tax, 6 lakh 56, and client pays me on account.
Yes.
25 lakhs.
Yes.
Have I collected the service tax with the 25 or not, sir?
Okay. Solve that. I was thinking chart account will come to account, on account. Correct, that's wrong.
This is a practical problem because I have charged the service tax to the customer.
One ITR, let me note down, for this time I got the citation. One ITR 94, 1993, volume 1 ITR 94. Maharaj Kumar Kameshwar Singh, 1933, Privy Council, first volume of ITR itself. Okay.
Brief on the case.
I was about to mention this. I'm extremely happy you people.
Preempt the things.
No, not the preempt. The very next point. You have put it on logical straight. He also asked at the logical time only. He didn't jump the gun. That's the very next point. Very good. And sometimes I miss it out. I was telling Rajiva in the morning. In this Raja Amartya you are seeing, the Britishers, all the leading judgments and income tax paid 50 are all with Rajas and Maharajas. Because Britishers got hold of their main fellows and everything else is against them. Okay. That part was money lender. Okay. Then the customer has repaid money. Ordinarily, in commerce and business, when you repay the money to the lender, it will be adjusted against the interest. First adjust, then against the principal. Income tax department doesn't do that, no? They normally adjust against the tax. Income tax department adjusts against the tax, but if they really do it against interest, you will be in trouble. In all sales tax law sections specifically say, if the tax, interest and penalty and the amount remitted by the party is less than sum total, you first adjust against penalty. Penalty बचने के बाद interest, then you adjust against principal करके sections are there. Okay. Income tax is silent now. There is an old rule 6 or something which is deleted. I will tell you the story separately. In this Raja Kamakya saying, the borrower paid money. Okay. This fellow deliberate adjust against principal only. The income tax department said, if you adjust against interest, I will get income tax on interest. Okay. If I adjust against the principal sum, he doesn't get tax. Therefore, income tax argued, ordinary way businessmen appropriate would be towards interest. Therefore, I am entitled to presume that he adjust against interest. Therefore, I will income tax on that. The Privy Council rejected it. It is open to the assessee to adjust it in the manner most prejudicial to the revenue. This is very language used. Most prejudicial to the revenue. Therefore, even in a case where you raise principal and service tax separately, customer does not, he makes on account payment. He does not say that adjust against this or this. Then it is open to you to adjust any one of them. Therefore, in your accounts, if you have two liabilities, I don't know how you people account it, then you can show I have adjusted against this portion of it. The difficulty is that principal interest case and your case is, there are two different debts, one the principal sum and interest. Here when you raise it in one single debt, there are not two debts due from the customer to you. Okay, no two debts due. But then you cannot assume, minimum first thing you can say is, when against the full invoice is 50 lakhs plus 6 lakhs, or 56 lakhs, he pays 30 lakhs. Revenue cannot assume that 30 lakhs first is adjusted towards 6 lakhs. Balance it to this. That cannot be done. That Raja Kamakya saying is very clear. Okay. Suppose he pays more than 50 lakhs, then what can he do? Suppose on-account payment is done against 2-3 invoices. Okay. Suppose he makes a payment of 52 lakhs in this. Is it open to adjust 50 lakhs in the first invoice and 2 lakhs in the next invoice? I am not clear on that.
So under the contract act, the
Clayton's rule, contract also is subject to contract to the contrary. 59, 60, 61 rule in Clayton. That is when more than one debt is there, you can act. If it is not appropriated, then it will be sequential. But if you appropriate against any, no difficulty. 59, 60, 61, that this can apply to tax. Can you also note this? That this principle of adjustment, appropriation of payment can apply to tax laws. Our Supreme Court has said in that Opera case, 83 STC, Telco, V. Ramaswamy's judgment, Justice V. Ramaswamy's judgment. Because they will say contract law, our tax law is supreme, lower and everything, as it is the only law existing in the world. So Telco's judgment says Clayton's rule can apply. What happened in Octroi? You can claim refund if the goods are within 6 months is gone out. Okay. So easiest way to harass anybody is please prove each nut and bolt which for which a claimed refund has come back within 6 months. telco will importing hundreds and thousands of cars into Thane municipality and taking it out of the territory. You link on one-to-one basis. We are not linked, therefore assume everything is beyond 6 months, reject the refund. That was the stand of Thane municipality. That the Supreme Court said you can follow Clayton's route, you can adjust first in first round method. So 83 STC is an authority for first in first round method. Clayton's route can apply for this. Secondly, 45 STC Vijay or in Kerala High Court went into this question against adjustment of dates itself. It is open to the creditor to adjust 45 STC. Therefore, if you have one invoice of 50 lakhs plus 6 lakhs, next invoice of say 20 lakhs plus 3 lakhs, okay, and the party pays is 52 lakhs, I don't know whether you can say Clayton rules apply, then 2 lakhs is better against this thing. But open you to adjust against, need not be the order. Is it open you to adjust 50 lakhs is the first invoice and 2 lakhs against the 20 lakhs is the second invoice? I am not clear on that because problem is a single date. As the question as to whether when it is a single date, each, because it is not 2 days against each invoice, you keep 1 date and 6 lakhs another date. I don't see any reason why, if party adjusts, the person who tenders equipment doesn't say, why he cannot adjust the way he wants. If the communication principle is correct, why he cannot adjust? Plus you are concerned with criminal liability. Okay. So, as far as collection service tax is concerned, this is all I wanted to say. Invoicing is not enough. Provision collection is not collection. The section is not retrospective. Offence is taken place on the day it is. And it is open to you. When on account payment, certainly you can adjust the way you want. You need not adjust against the tax portion first. Okay. And when you have more than 1 day, possible.
Sir, in case if there is any inquiry or investigation is going on, tax liability is not decided. In that scenario also they can. We have charged, maybe bills are there, quantification is not done.
Quantification not done means?
Like they have booked a case, preventive has booked a case against the SSE. They have seized some records and all, and on that basis they have concluded that this much amount is exceed of 50 lakhs.
You collected.
Like our invoices are there, and on that basis they have concluded.
Charged.
So what is the, okay, before going to this question you just now read, what's the practical thing? In all these matters, when there is a likelihood of this problem arising about arrest, etc., of course you will examine the matter from these legal angles and put in a written representation making out a case how it is not corrected by these reasons. Give legal arguments, let it come on record. So that at subsequent stage, if they create trouble, because firstly if you put in a proper thing, they also are careful about it. Okay. And subsequently you can say there is a serious dispute as to whether I have corrected or not. Is the problem again, this fellow will rob with the assessee and get a statement recorded.
Confirmation.
So you must be careful that if you have, because they don't understand this legal principle that easily, the Clayton rule, collected means this thing on account payment, etc. Therefore, you must keep a template in your system ready. Okay. And modify the template, don't use it mechanically. Modify the template, and that representation should go. Whenever this oppressive industry is going on, repeated summons are taking place, that should be not what you need. You should not argue this for the first time before the court or the magistrate. It should go already on record. So that you put in a, whether they listen to it, read it, understand it is not your problem. Because that also puts them in the back foot. Now, what's your question you asked, sir?
Like in case of preventive inquiry or like that, without concluding the tax liability, then they arrest on the assumptions, presumptions of. But as you said, that confirmation statement is there of the SSE.
Well, your invoices are also there. And these invoices are not shown as outstanding in your books. Then what else is needed? So you are, with your suggestion that there is no assessment. See, if he says, if the section says anybody who has evaded tax beyond 1 crore, we will arrest. which is the mistake they made in the section as it stood prior to 2011 when the Om Prakash judgment of the Supreme Court came. They said, how do you know it's more than 1 crore? Till the time assessment is done. If you link your prosecution and arrest with the duty evaded, in a case like customs where gold is found, a non-declaration, straight away there can't be a defense about it. Or duty liability is there, straight away there can't. But in a case that assessment is to be done, we estimate the liability. Okay. Then you can say, look, the section won't apply. But here, 89D refers to collection exceeding 50 lakhs. You will certainly to take this minimum precaution of showing that invoices were raised for this, and as Raji was mentioning, everybody will have more than 50 lakhs nowadays. Nothing much in this. So there is nothing for even without the statement. You can disprove it only by showing on account payment or more outstanding is there. I have adjusted against principals in all the invoices. I have not adjusted against anything towards tax. I am telling also there may be deferment of tax under Rule 6, but 18 and 1 does not allow. Otherwise, when the invoice is there and amounts are collected, then you will have difficulty on that.
Sir, last question, sorry.
No,
So what about the liability and the reverse charge?
Will not apply.
You have not-
Certainly not. Sorry, I wanted to mention that.
You are not collected.
You have not collected, so.
Absolutely plain. Every liability is not governed by Section 89. There is no complete exhaustion of all situations where liability tax is there.
Any collection.
Any collection. In fact, we had Section 140A3 Sali Maria judgment of the Madras High Court. 140A3 self-assessment tax, if you defer, you will be liable for penalty in the section. The P. Ramsu struck down the section, saying where is the question? If there is a delay in payment of tax, you can collect interest, you can never impose penalty. But that was reversed to the Supreme Court. There again he said, this can never apply to indirect tax. Indirect tax part is generally correct. Anything else in this? Anything else?
We have 5 more minutes if you have any questions.
Yes, sir.
So this word knowingly evades the payment of taxes, how loose it can be?
Bhaiya, that is for prosecution, no? That's for criminal lawyers. You don't worry, there will be no arrest on the ground. Knowingly in matter of this thing, you can certainly find out some circular of the board, some lawyer would have given an opinion, some tribunal single member would have taken a view in your favor in most situations. So that is not, this is not, in this country you can trust some judgment taking a view in your favor. Okay. Or some commissioner is deciding in some favor. So knowingly evades is very easy to get out. Saying that I had a bona fide reason extra. And that's a matter for trial subsequently. There will not be a ground for arrest. Okay. Again,
Assess in default.
Huh?
Assess in default. Under the recovery proceedings, assess in default. Service provider tax, they are issuing notice to me.
I'm coming to the next point, sir. That is for recovery, no?
I am only on this, sir. Because that can fall under 89D because, general impression is created. Okay, once this is done, assess in default is in the shoes of the assessee himself.
Hi.
That is what apprehension, sir. Apprehension.
So in other words, he's saying if a notice issued to the bank to hand over the money
Yeah.
due to the assessee to the tax department, it defaults it.
Yes.
89 is available. No. Firstly, there is no section, unlike our 226, which deems that person to be for these purposes also. None of the clauses will apply.
Because they are trying to untwist the other person.
But that's plainly not applicable. So good question. Yeah, question, sir? You want to say something? Okay. Shall we then go to recovery, sir? So you are talking about recovery because he was mentioning that recovery is also practical this thing. Two distinct things. Recovery during investigation and recovery after the assessment order is passed pending the tribunal application. Second is purely legal problem. First is both a legal as also a practical problem.